A former employee with the Guam Office of the Attorney General bringing her case before the Civil Service Commission to fight her termination. Child Support Enforcement Legal Clerk Josette Guzman filing an appeal contending her dismissal violated personnel rules and denied her due process. Guzman is represented by Guam Federation of Teachers lay representative Robert Koss.
Hiring and firing rests with the agency head, okay, not line supervisors. That's an authority that cannot be delegated away. So in this case, we have a line supervisor who has terminated an employee. That's a violation.
Koss adds Guzman was not issued a notice of proposed adverse action. Without this, he says she had no opportunity to answer to the charges before she was fired.
That document needs to state any and all reasons specifically and in detail as to why the employee is being accused. It also should state that it's not a matter already decided, that the employee has a right to submit a response or an answer to that proposed action in her defense.
The AG's office also filing an opposition motion. They argue the final notice of adverse action makes it clear what she was being dismissed for. The document stating she was fired for, quote, refusal to meet the deputy and HR when specifically ordered to, refusal to submit to drug and alcohol testing attendant to an alleged workplace injury, exhibiting histrionic behavior in the workplace, and posing a threat to the safety of others in violation of violence in the workplace policy. Koss calling them vague and general allegations.
I submitted a discovery request on behalf of my employee, and I'll provide you that document. And that discovery request asked them these questions, provide us that information. Tell us, when was this meeting? Tell us when you asked for a drug test. Give us those documents. They withheld them. They have not responded to the discovery request. Now they're saying we can't meet our burden of proof because they're not giving us any information.
He even accuses the AG's office of withholding information, calling it ludicrous and absurd.
They don't believe that public employees are required to be given a notice of proposed adverse action or due process. And they argue we can't prove our case because they won't give us our discovery. This is ludicrous. These are absurd responses.
He adds an offer to settle was met with deafening quiet. Koss and Guzman will argue their case before the Civil Service Commission on November 30th.